All right. If we'll take the next minute or two to go ahead and look over the meeting minutes from December and March, while everyone's getting settled, that would be appreciated so we can move along pretty quickly.
Are you a new board member?
Yes, ma'am.
The lady right here on the end will be able to help you. Thank you.
Surrey Lake Broken Trust.
We've got several new people that have, that are coming on next term that are here today with us. All right, we're going to go ahead and get started this morning. I'm Leanna George. I'm the chair of this committee. We've taken the last few minutes to start looking over our minutes, but I know we have several new individuals here with us today that will be starting their terms in just a few weeks. I welcome you. I'm glad that you're able to come and participate today in our meeting. We have a few that are going to be leaving us, and we'll discuss that more later, I think. But anyway, I'm the parent of 2 children, both of whom have exceptionalities. They are awesome kids, but they're not here today. My son's usually with us because he's homeschooled, but he's at camp today. And I have a daughter who lives in a group home attending school out in McDowell County. I'm from Johnston County. And do we want to go, would you like to be next, Janine?
My name is Janine Velocity from Wake County. I have 2 children, the youngest of which is my EC kiddo.
Hi, my name is Vicki Simmons. I'm an adapted physical education teacher with Guilford County Schools.
I'm Dale Carpenter, professor of special education at Western Carolina University, the outgoing IHE representative.
I'm Jenny Moorfield. I have a son with traumatic brain injury in an ID severe class. I'm also an interpreter for the deaf, as well as a teacher for hearing kids, but for ASL.
I'm Tim Montgomery. I'm head of school at the Piedmont School and John Yale Academy in High Point, North Carolina. We specialize in working with students with attention deficit disorder and other language-based learning disorders.
Christy Hutchinson, EC Director, Lincoln Charter School. So I'm the charter school rep for this council.
I'm Christy Grant. I'm the Exceptional Children's Director at Nash Archie daughters, 4 with autism, and autism resource specialist.
I'm Hugh Blackwell, and I'm the North Carolina House of Representatives.
I'm Tish Bynum. I'm Special Assistant to the North Carolina Governor's School and administrative support to this council.
Good morning, I'm Becky Scott. I'm the court reporter taking our record today.
Good morning, I'm Carol Ann Hutchins. I'm the Section Chief for Policy Monitoring and Audit here at the Exceptional Children's Division. And I'd also like to introduce one of our participants via virtual, and that's Paulette Wall. She's joining us virtually.
And I'm Marge Tierhart, Professor of Special Education at Meredith College, the achiever, and mother of 2 children with ADHD.
I'm Anthony Baker, Assistant Principal at Western Middle School in Elon, North Carolina, and former EC teacher and chair.
I'm Teresa Mebane. I have 3 boys on the autism spectrum, and I live in Wilmington. I also work for the Autism Society of North Carolina and Family Support.
My name is Sarah Bigley, and I'm the state coordinator for foster care, which is new provisions for children in foster care under the Every Student Succeeds Act.
Hi, I'm Kristen Hodges. I have 3 children. 2 have IEPs. 1 has a 504. I also have a sister with Down syndrome, and I'm a school counselor at an elementary school.
I'm Abby Childers. I have 2 children. My son is 11 and has muscular dystrophy, and I have a daughter with something called Dravet syndrome, and she is 9. Both are students in Charlotte-Mecklenburg schools, and I am also the EC Parent Advisory Council Chair.
I'm Diane Coffey. I'm from Watauga County, and I am a parent of 2 children, both with exceptional needs.
I'm Cynthia Daniels Howell. I'm a parent in Wake County. I have 6 children, and several of my children are diagnosed on the autism spectrum. I'm also a special education advocate, so I work with families across the state.
I am Adam Johnson. I'm the Director for Education Services with the Division of Juvenile Justice.
Hi, I'm Jennifer Grady. I'm a business rep. I work for Blue Cross and Blue Shield of North Carolina, and I'm also the parent of a child with autism.
Thank you very much, everyone, once again, for your participation today. I'd like to move us on with the agenda. And so we've got several subjects to discuss today. We're going to be receiving a report on the Andrew court outcomes and how that's affecting North Carolina schools. Also have technical changes to policies coming up, and after lunch we'll be doing some committee work and working on our annual report. Do we need more time to look at the December 2017 summary of action or minutes? If we do, we'll take another minute or two. If not, if I hear a motion, we can move to accept them as written or as edited, whichever's needed.
So I'll make a motion that we accept them as written.
All right, do I hear a second?
Second.
All in favor? Aye. All right. A half a dozen people. Whoever wants to raise their hand and volunteer to read the second officially.
I think the gentleman on the end.
All right. And same process for March. Do I hear a motion to approve?
Make a motion that we approve as written.
All right, do I hear a second?
Second.
Okay. All in favor?
Aye.
Aye. Okay. Anyone else need it locked in while we're doing instructions? Hi.
I apologize for being late. My name is Hannah Carter. I'm the Director of the Division of Child Development and Early Education.
All right, welcome. Thank you for attending today. And we're moving on to Ms. Hutchins with injury.
Good morning. I provided you a handout that came a little bit after your packet was constructed. And it's titled Questions and Answers involving the Andrew case. So I'm going to share with you today a little bit about the Andrew case, what we are looking for in terms of how that is impacting what we do for children with disabilities in our schools, and answer any questions that you have about that case to the best of my ability this morning. I'd like for this to be a little bit informal, so as I am presenting the content, if there is a question that comes immediately to mind, I'm happy for you to stop me so I can either clarify or respond to the question at that time. And I'm also multitasking for our guests who are going virtually, so I apologize if it may not seem very smooth, but I'm going to do my best this morning. So again, we're going to talk about some legal trends with the Andrew case, both nationally and here in North Carolina. Then we'll walk into the technical changes to the policies that occurred over the summer, last summer, and adopted into this school year. Many of them were prompted by changes to the federal regulations, so I'll walk you through that. Then we also have the House Bill 149 for dyslexia, and then we had some changes that we initiated on behalf of the division as it relates to the LEA self-assessment and identifying students suspected of a visual impairment. So to give a little bit of context about the Andrew case, I wanted to share a little bit about this student and his unique needs before we walk into what the outcome of that case was. And just bear with me if you are already familiar with the case. First of all, this is a young student that was eligible to receive special ed services under the disability category of autism. And the dispute is that when the parents and the IEP team met for their annual IEP team meeting, the parents felt as though there was no real change to that child's IEP. In other words, they were seeing similar goals, if not the same goals that were proposed before. they saw little to no progress, or they felt like there were areas that had not been addressed in any particular form and fashion that was different from what they always had. So in essence, they felt like their child was getting the same program over and over again, and they had concerns about that naturally, and about whether or not the child was actually making progress. And so the dispute went through a couple of different avenues, of course, the ultimate being that the family filed for a due process petition. And during that timeline as well, the parent withdrew the student and enrolled them in a private school that was specially designed for children with autism. And so during the time that the child had been removed from a public school setting and placed in a private school setting, the child actually had improved behaviors. The child had new academic goals that were strengthened and more rigorously designed. And by testimony in this case and the evidence that was put forth as far as data collection, there was evidence to support that the student was considered to be thriving in that change in placement. So then in the course of litigation, some important events were that initially when the case was heard, the FAPE standard was applied, meaning de minimis progress. And how many of you have heard that term, de minimis progress? Essentially what it means is that any progress is sufficient progress. And so that was the threshold for providing a free, appropriate public education, is that if the student made any progress at all toward the goals and objectives on the IEP, then the student was considered to be receiving FAPE. So the first time it went to court, the court ruled that while it may not have been the best IEP, there was progress made for that student in his public school setting. And so essentially they said that the child did make progress, so they did not see a denial of FAPE. Clearly, the parents still had a disagreement with that finding and pursued their procedural safeguards and went further and appealed that to the Supreme Court. So in March of 2017, the Supreme Court actually overturned that decision, and that's where I think a lot of parents for the first time started beginning to hear of this case, if not just shortly before that, because it became a national case to watch, if you will, because the FAPE standard had been challenged successfully now for the first time since the de minimis standard was set. And so in March 2017, the Supreme Court actually overturned that decision of the Circuit Court, and that it determined that in order to meet its substantive obligation under the IDEA, a school must offer an IEP that is reasonably calculated to enable a child to make progress in light of the child's circumstances. Now, in looking at this, of course, all of the whole country started wrestling with what does this really mean? So are we going to finally put a metric in place by which all children have to be measured? Is there a metric that can be established unilaterally across students with disabilities that can, without a doubt, say the child made progress? Well, as we all know, the most important part of our business in working with students with disabilities is that they're all different, and they all have different needs that present at different times, and they have different intensity, and they require different strategies to support. And so in wrestling with this issue about how to put some quantitative measure on what is FAPE, the difficulty rests in you can't find a measure that is appropriate to measure every single person's unique need at any one moment in time. And so as a result of not being able to think of a metric, those of us in the education field started wrestling with the question with, so what's changed and what is the expectation for us to provide a free, appropriate public education? Because each child is so different. We're not being given necessarily a metric that spells it out, what we have to meet. And is this any different than the de minimis standard? And for a good while, there was a school of thought that there is nothing different about the de minimis standard, that any progress is progress. But really, when you start getting into the case and you look a little bit further, even though you cannot establish a quantitative measure for all children, there was some language as a result of this court case that really made school districts and state departments take a look at what we were doing, what we were messaging, what kind of supports we were offering to school districts, and the expectations that we were setting forth for students to make progress. And so some key phrases here that have always been in play but really came under the microscope as a result of this case is the IEP is reasonably calculated. We've always had the obligation to ensure that an IEP is rigorous in its goals and objectives. We want to plan what we reasonably believe that the student can achieve in the life of that IEP. And we need to consider the supports and supplemental aids and services that are required to be able to help that student make progress on those goals and objectives. So the reasonably calculated started the questions of what is different now? How can we ensure reasonably calculated? Because we've been writing IEPs for some time now, so what does reasonably calculated mean? And then the second part of this statement that's really important is in light of the child's circumstances. What does that really mean? Does that mean the child's present level of performance? Does that mean the severity of the child's disability? Does that mean their current performance in a general education classroom? What all are the ingredients of a child's unique circumstances? And so those are the areas that those of us in working in state departments and of course at the local level really started to try to put some meat on the bones so that we can help the implementation and practices at the local level appropriately raise the standard for our students with disabilities to make sure that they had a reasonably calculated IEP and that it was based on their unique circumstances. And so this case, after that March 2017 ruling, it actually was remanded back to district court because the Supreme Court said, you know, it's not good enough. So it's got to go back to the district court. So what happened here is based on that additional information and that stronger language about progress is just not good enough, progress for progress sake is just not sufficient, it was remanded back to district court. And then in February, just a few short months ago, what happened is that the district court said, yeah, we have a problem here. And so the parents prevailed in this case, and the judge ordered reimbursement for the cost of private school and the associated transportation costs for the time that the child had to be provided an education through a private school placement. And so the lesson here of course, is multiple things. Clearly, the school district involved was not able to show where this child was currently performing and what was needed to continue moving that child forward. And the fact that the IEP had not changed substantively to adapt to either the progress that the child was making or was not making was also a difficulty in this case because they could not show that that IEP was reasonably calculated for the student, nor did they have the data to support that anything above just minimal progress was being achieved. And so one of the hard things about this case when you look back in time is this dispute started in 2010. And so this was a long process for the family and the student. And so just some other tidbits around this. The district is now vulnerable for other damages, costs, and attorney fees as a result of this prolonged legal issue. And the local education agency in this state now has upwards of 7 figures of costs that they'll be paying for this experience and to get the student back on track to performing the way that they should. And so, again, what does this mean for us at the state and local level? And so when I talked to you a little bit earlier about there is no one measure that can be put in place to determine whether or not a child is making progress. So it's difficult to know what an appropriate progress or appropriate rate of progress would be for a child. So then the IEP teams have to have policies, procedures, and practices related to the following. And so looking at critically here, the present level of academic achievement is even more important than it was before, because you can't possibly know where you're going if you don't know where you currently are. And then having appropriate measurable annual goals, that speaks to having the rigor of the program and having an appropriately calculated IEP that needs to include academic and functional goals. And so the setting of measurable annual goals is essential based on those present levels of academic achievement. So you have to have good information on which to base those measurable goals, and then those measurable goals have to then be measured in a way that is easily understood and is sensitive enough to actually measure what you set out to do. And so that leads us into item number 3, is that how are we meeting those annual goals? How are they being measured, and how are they being reported? And so it's a real emphasis on the push for good, solid, reliable data that can be collected over time, that is directly related to those specific measurable goals, and that upon either progress accelerating or not accelerating as anticipated, that the IEP team does in fact meet to review and revise that IEP, even if it's before the annual time, so that that IEP can remain appropriately calculated for that student to make progress. So I'm going to stop and take a breath here and see if you guys have any questions. Okay.
I just had a comment to make about this, and that is because I'm not in as dire a situation as Andrew's parents, but I have been going through, in preparation for John's next annual IEP, I've been going through all of his report cards, all of his IEPs, to see and compare those with the extended standards in North Carolina. And I'm noticing the same thing. From grades 2 until I think I've gotten through 4th grade, his goals have not changed. Now I know that there's some other reasons there, but that I'm addressing with the school. But unless parents are involved, there is no way for the state and the school districts to ensure that a child is getting these appropriate and measurable goals. Because like the only reason that I caught it is because I pay attention to what he can do in therapy and what he's doing at home, and then I'm looking at an IEP going, okay, I know that he can do that, so why is it still on this IEP? But if parents are not educated in this process, or they're just not involved as much, I'm not sure that there is a way for us to make sure that kids are having appropriate goals written for them and that they're reaching the standard or reaching the progress that they can do.
So I think you've raised several really important things to think about a little bit further in your comments. And one of the things that is really hard with the Andrews standard is to be appropriately able to calculate that IEP based on those unique circumstances. And some of those unique circumstances is that all children's rate of progress can be different. They can also be different at different times. We have students who are able to really accelerate quickly in some areas, and then there are some children that have to have some level of maintenance skills planned in their IEP because of skills that are difficult to hold on to, and so they have to be worked on in cycles to make sure that they are maintained. And that's where the functional piece comes in. We know that if students are functionally using those skills, they're highly likely to retain those skills longer over time. And so you mentioned some really important challenges that we have with the Andrew case, and some of the things that we have tried to do to support LEAs with that task and to help parents understand present levels of performing is as we have gone through the revision of our forms and our documents, you will have noticed, or you will begin to notice, that the present levels of performance are all concentrated together at the very beginning of the IEP. One of the things that we reflected about in how our IEPs are organized is that it could be perceived as choppy and not have a good flow in its current state, because you would have a present level of performance. You go ahead and talk about a goal. You talk about maybe the services related to that, and it could be choppy because you focused on each area all the way through at one time. And so what we've tried to do organizationally wise in our new forms going forward is we want to know about all of those unique needs at one time. You have to have the landscape of the student's strengths and the student's areas of opportunity for growth early on and in a complete total picture before you get into programming. Because what you want to really do is make sure that you can maximize the strengths that the child has, revisit any areas of opportunity for growth to strengthen, and then consider all of the different things at your disposal in order to address that, whether that might be through rigorous goals and then some supplemental objectives, whether that's through any type of support plan such as a behavior intervention plan, if there's a health care plan that is needed, if there are supplemental aids and supports that are required in the general ed classroom to continue with that participation. That is one of the things that we have really emphasized in the restructuring of our forms, is so that the IEP team is focused on everything that we know about the child all at one time before we go into planning.
And just one last thing, and it just came to me, but like I know that his therapist at school, you know, I sign off a waiver and they can talk to his private therapist as well. Can we add on those forms when the IEP is being created, can we add like outside professionals who have been consulted in regards with the child? Because I know that we can't require, you know, information come in from the outside, but can we add like whether or not the child's maybe a psychologist, a psychiatrist, physical, OT, speech, whatever? Can we just make an area in the form that says these, you know, these professionals have been consulted, and, you know, if they can send in a report or something that would help us get, because kids also are different outside of school.
Absolutely, absolutely. Well, I would encourage parents, as they are receiving information from the school in preparation for their IEP team meetings, if they have information to share about activities that are going on in the home setting, that is all good information that is really necessary for appropriate planning, because we have to have the complete picture of the child's performance. And as you mentioned, children can be performing in different settings. Your child might have had a lot of success in one area at school, but you're not able to see it at home. So then that raises the question, if the skill is truly acquired and mastered, it should be generalized across settings. And so the same would be true for things that are being able to be achieved at home. What is the barrier for it not being achieved at school? And there's differences, of course. Those skills may not be needed at school or at home and vice versa. And so that communication between the settings is really critical to establish those present levels of performance and planning to move forward. So yes, I would encourage parents. There's lots of different ways that can be included in the IEP. That can be included certainly as outside information that the parent provides, and that becomes part of their present levels of performance that the team considers. It also can be raised through the parent concerns that's documented on the IEP team. And it's also just part of advocating for your child during the planning of the meeting and the proposal of goals and objectives and services that are then considered as the team moves through the process. Yes, ma'am.
One of the things that I have run into recently that I find just would be helpful for DPI to maybe define more is when there are conflicts in data. conflicting data points. So maybe one set of informal tests says this, another set of informal tests says that, and kind of what the policy should be for school systems, because, you know, when there's a situation where, let's say, the child's performance, they can access a certain level, but accessing it maybe on an instructional level versus an independent level. But when they do certain tests, you know, to look at fluency or encoding, decoding, whatever, they show that they are significantly below grade level. So that kind of leaves a quandary as to, okay, well, which data do we believe? And then if parents go outside and get other data, how is that figured into the decision making? Because I feel like there's a lot of gaps in what districts have to do when it comes to progress monitoring. It's not very clearly defined. It's not defined when assessments, for instance, don't, not that all the assessments will say the same thing, but if there's, you know, gaps in that, what needs to happen next? Because then you're kind of stuck at, well, all the data points don't point to this, so then what do we do? How do we serve this child? So I feel like there needs to be some policies put in place that say, when you have measures that conflict, you maybe need to get an outside opinion or whatever, so that there's clarity, because that lack of continuity and direction can lead to like not knowing what to do, what's best for that child, you know?
Sure. So what I can share with you is that we do have policies in place regarding multiple sources of data. Students cannot be determined eligible for special education on just one piece of data, nor should their IEPs be developed on just one point of data. So consistently through our policies, there is the reference to programming for students that is based on multiple sources of data. That's why we don't like things like report cards necessarily, you know, just results of end of course tests. Results of end of course tests are episodic. It doesn't give us data over time with how that child is performing. And so it is a policy requirement that decisions for children with disabilities are based on multiple sources of data. I think what is going to be really hard when we think about children in their unique circumstances is that there isn't going to be one assessment either that is going to be the dividing rod between how the child is performing and how the child is really performing. So what we have to do is we have to look at the preponderance of the information. So if we're looking at multiple sources of data with reading assessment, whether it's informal classroom performance, standardized testing results, more formal assessments that are obtained through parent consent, maybe through a reevaluation, you have to look at those results all together to determine the best course of action for a student. Because if they are showing different things across those different assessments, I think it's pretty clear that we have work to do, and we might have to have significant work in multiple directions. Because the other thing is that we can't assume that one measure is the definitive measure. We have to look at all of them concurrently.
But that's kind of what I'm saying, is there's nothing, I mean, I understand you have to look at everything, but when everything kind of is all over the place, there's no guiding information that says, okay, if you have a series of things that all don't connect, what is the next step? Do you know what I'm saying? Because like me as the parent, I'll have to go out and pay for testing to find out. Do you know what I mean? If all their data points disagree, that leads us nowhere, even if they're considering all of it. How do you guide the district so that data can be collected so that we have a better idea? Because if you have all these different pieces, you know what I'm saying? You have all these different pieces and then no guidance as to how do you find out?
Yeah, I guess I look at it a little bit differently in that students and their disabilities present very differently. And we know that students with disabilities have splinter skills. They may show relative strength in very particular areas and then little to no strength in areas that could be related. For example, fluency and comprehension, there could be a real difference between the two. And it could be related to the way the test was administered. It could be relative to the child's disability and how he or she performs on that test. So I still think that there is a real challenge there to have a definitive, this is the best thing to do. But what I can share with you is, in addition to any kind of formal and informal assessments that the school district is able to provide, that IEP team can consider going beyond the assessments that they have on record and determine whether or not another specialty area assessment needs to be obtained. And again, just also companion to that, if the parent is still in disagreement with what those evaluations say, they can make a request of the LEA for an independent educational evaluation at public expense to pursue further data. And there are some guidelines that are associated with that independent evaluation, of course, but that is a right that's available to parents. Okay? Yes, sir.
Wanted to be sure I understand this handout. It says up at the top, December 7, 2017, questions and answers. And in the second paragraph at the end, it says that the Department of Education Special Ed Office is interested in receiving comments from families, teachers, administrators, and other stakeholders to assist us in identifying implementation questions and best practices. Those questions and best practices would be different than the questions and answers that are here, correct?
So there's two ways to respond to that. Yes, there would be more perhaps FAQs that would accompany this document that are not currently here. The second thing is just the U.S. State Department, as are we, are looking at how to best manage the raised standard now for FAPE and what kind of technical assistance and supports do families and states need from the Office of Special Ed Programs to continue moving forward.
Well, that's sort of where I was going.
Mm-hmm.
When do we anticipate that we will get additional guidance or suggestions as to best practices that might align with this decision from the feds? And when will, I guess, the Division of Special Ed here in the state, when are you guys going to have something for the LEAs?
So the first part, as far as when is any kind of additional information is coming from the Office of Special Ed Programs, that is a hard one to say. We don't have anything currently as an advance notice that they're getting ready to publish anything. However, if they follow their pattern last year, they issued a lot of updated information around July, which is why we have some policy updates that I'll provide in the second part of the presentation. And then as far as what information we've provided for the LEAs, we didn't wait to provide any further information. We made this available on our website as soon as it was published. And this, yes, sir. And we also shared this same presentation at our Directors Institute in March of this year. And we had the same conversation about the rigor of the standard for the students, basing information on the program for the student on good, solid data. The emphasis on progress monitoring and multiple ways to monitor progress.
This stuff and what you've told us this morning, it strikes me as pretty general. Do you all anticipating getting a little bit more specific with your suggestions?
I do, actually, and one of the things that we have talked about with this group is the launching of our ECAT system, which is our statewide system for managing the programs for students with disabilities. And as a part of that program, there is a progress monitoring tool that assist LEAs in setting those measurable goals for students and then being able to measure them and graphically display them to be able to share with parents so that parents have a good idea about how their progress is going for their students. And then secondly, we have a host of training that we are providing to LEAs on specially designed instruction based on good data. And we have partnered with the multi-tiered systems of support for what supports are being offered in general education, and then at what point does the special education services need to elaborate, enhance, and extend upon those general education interventions so that the child's unique needs are met through a variety of resources.
Well, one final question,
Sure.
I think sort of relates to what you were just saying. Clarify for me, as the division understands it, how often does an LEA or a school system have to revisit an IEP?
So there's two conditions. At minimal, it's once annually. And then the requirements is that if there is a change in the child's progress, they have a responsibility to review and revise that IEP, and that can be more often than annual. And then a parent can at any time request an IEP team meeting if they have concerns about their child's progress.
I don't have another question, but being a non-expert, I have nevertheless an opinion to offer or a suggestion. In this day and age when we're talking more about personalized learning, it seems to me if you're really going to focus on the unique circumstances of any student, be they special needs or otherwise, that you can't wait a year and get to the end of the year and say, well, that didn't work. What are we going to do this coming year? We now have all this data. We've got computer programs for evaluating and stuff. It seems to me that the division ought to develop an approach that encourages our special ed teachers, just like our regular classroom teachers, to look at student progress weekly even, and to adjust in relation to whether there is or isn't progress made. It may be that a special needs student needs to be approached a little differently. Maybe somebody makes slow progress and you don't look quite as often. Maybe somebody is not dealing with an academic issue, but they're dealing with other issues. But it seems to me if you're going to be aware of the unique circumstances that you've got to adjust more often than annually.
Yes, sir, and we would agree with you. And in fact, the purpose of progress monitoring is to look at progress daily, weekly, monthly, and that is what we encourage for students who are receiving education in a public school setting, and that they don't wait. And you're very correct. We have a lot more data easily available now, and to have the discussion on how the child is doing, it's not appropriate to wait for a year. And so we don't encourage that teams wait to make changes at the annual date if changes are necessary ahead of time. And in fact, if parents raise a state complaint to that effect, we find them in violation of their responsibility to review and revise that IEP when that child's progress doesn't go as anticipated.
Caroline, I think it's important too to mention that in an IEP, it indicates to a parent and a school system how often we provide updates on their IEP goals, and the very minimum, that's quarterly. So every 9 weeks, we'll say, and on average, a parent is receiving progress on every single IEP goal. And some IEP teams determine it's more frequent than that, but at least every 9 weeks-ish.
Well, there's a difference, though, I think, in a progress report and adjusting the IEP in relation to the progress. Just sending out a scorecard, like getting a report card, is a different matter than saying, because of this, we've decided we need to do something differently. And that's the piece that I'm questioning.
Okay, thank you.
And I have just one thing to add about that, because I know that as a teacher, I was required to have grades updated in PowerSchool at least once a week. Is there anything in PowerSchool that we can use for our special ed teachers, just to maybe have our child's goals listed, and then the proficiency scale that they use, the 1 to 4, kind of about where they are, because most teachers will send home a communication folder so you know what they did that day, but as far as their progress towards a goal, be it physical or academic, there's really no way to know until we get that progress report every 4.5 weeks. So does PowerSchool have something that we could use?
PowerSchool is not currently constructed to share progress on IEP goals. However, to the rate of progress that progress is communicated to parents, that can also be an IEP team decision, because the minimal is as often as typical children receive report cards. However, it could be more frequently, particularly if children are either slow to make progress or their progress is intermittent and can spike and then hold for a period of time. So the IEP team can articulate how frequently that progress is reported to parents. And there's a lot of times that IEP teams have communication that incorporates a weekly progress note or bi-weekly. It really just depends on how much time is anticipated that is needed for the instruction before a good assessment can occur to measure if the child is responding to that instruction.
And just for Representative Blackwell, we also have to make sure that it's feasible for our EC teachers to have the time to update weekly, because there's a lot going on in those classrooms. They don't always have time to sit down and report on what each child has done. But yeah, a good balance would be great to know what they're working, or just, just at least know what are they working on that week, so that we could reinforce it at home.
Okay. So just kind of to wrap up the injury part here, at the time that I put this together for the March Institute, at that point in time, there had been 501 cases nationally that have used the analysis of the injury case in due process hearings to establish whether or not a local education agency had in fact provided the FAPE standard to students with disabilities. And at the time that we had looked at this in March, there were 3 cases that our administrative law judges had actually cited and referenced the injury case when looking at the issue of FAPE for students with disabilities in North Carolina. And those 3 particular cases all had concerns, interestingly enough, around some of the behaviors of their child and whether their child's unique needs relative to behavior was being appropriately addressed, and whether or not that IEP had goals and objectives specifically focused on behavior, or if the child needed a behavior intervention plan, and so forth. And what the cases in North Carolina tended to look at is whether or not school staff could provide a cogent and reasonable explanation for the child's progress. And that kind of doubles back over the fact that if you are unable to have a measure in place to adequately measure progress and to make those instructional adjustments as changes in progress occur and cannot talk about it, then that raises the question about, are you able to provide FAPE, and are you able to construct this IEP when changes in progress occur? And so when school staff were asked to provide testimony in these cases, it was carefully listened to for that good explanation of data-based decisions. And what did you do based on the data that you had at the time? And did you have sufficient data in order to make the decisions and the recommendations that you proposed? Okay. Any other questions for me on injury? Yes, ma'am.
What were the outcome of those 3 cases?
So some of those were a mixed bag because there were multiple issues involving some of those cases. And I believe one of them is still being appealed, so there's not the final yet on that case. There was one instance in which the parent raised their due process related to not having enough communication from the school about the child's progress. However, the school district was able to provide documentation of extensive communication almost on a daily basis through email about the child's progress and how the child's day was going, using some of those informal means of the teacher-parent communication about progress that might happen from week to week. In this child's case, it was on a daily basis, and that the school did take reasonable effort to address the needs of the student in that particular case. And so there wasn't, I guess, to kind of get back to your question, there wasn't a clear win. There were some things that the school district had the ability to show good information for, and there were some other points, sometimes procedural things that the district did have a little bit of a problem with. So there wasn't a clear, win-win, except for the student, because the student is going to have the benefit of now having had people advocate on their behalf. The program will be stronger for the student. Yes, ma'am.
You talked about what you're doing to train the LEAs. What are you doing for parents? What kind of information is getting out there about Andrew and the updates to parents?
So one of the things that we are looking to launch as part of the implementation of the statewide ECATS program and the information that you heard me share about the organization of the forms, we are partnering with the ECAC group to develop some parent training that we hope to offer not only through their avenues and what they offer for parents, but also at the November conference, looking at some things to get together to present for parents to be oriented, if you will, to the look of the forms and what they might expect for their IEP team meetings. Also, as you guys are aware, we sent you guys a complimentary copy of the parent letter that went out to families describing our transition to ECATS and some of the activities that they may expect from the local level and getting ready for that. I think that Andrew has caused us all to look deeper into good data and how to advocate for our students and their programming based on good data. And so those are the strategies that we are putting in place for LEAs to be able to implement at the local level. And then, again, offering some more information about how to navigate the IEP process, even just from orientation of the new forms and the look of that and how their meeting might progress. And then incorporated in that, what are some good questions that parents should be asking in preparation for their IEP team meetings? One thing that we have encouraged when we have done some orientation with our LEAs about what to expect with the forms is that we've encouraged them to be okay with sharing information ahead of the IEP team meeting that is not considered predetermination. There are certain things, of course, that have to be an IEP team decision, such as what the services are, the accommodations. There are definitely points that the IEP team solely together need to discuss, but there's nothing to prohibit parents from receiving present levels of performance ahead of the meeting and even potentially some proposed goals that the IEP team might be discussing further. The way I see that, that's not predetermination, that's putting some good thought into what the team might need to discuss and at least providing some point of origin for the team to discuss based on the teacher's analysis of the child's present level of performance, and then the parent being able to see what the LEA believes to be the current situation for the student and where they'd like the student to grow. Then they can review that ahead of time and then add their thoughts to that when the IEP team comes together before that document is finalized. Yes, sir.
Just curious, did anyone ever think to ask the independent schools what strategies they put into place for this kiddo to suddenly start thriving and doing well?
I'm sure that is part of the case history, but I didn't.
That would be a nice piece of information to have.
I think if I remember from some of what I read to prepare for this, I think that they had smaller numbers of students. They had a higher number of highly trained personnel and a variety of specialty areas. So I think that was some of what was attributed to the child's strength. You know, it was a different setting from his public school experience.
Just curious.
Yes, sir.
In the literature about Andrew, there's quite a bit about that. Yeah.
Okay. Hey, Vicki.
Hi. This is for Virginia and for Representative Blackwell. This is my perspective as a teacher. Everything Carolyn said is true. Everything. That's the best scenario. But what really happens is that first day of school, some veteran teachers have retired, are retiring, have taken the knowledge and experience and wisdom with them. New teachers are coming in and they are not aware of the very special needs of our kids. They'll get file folders of kids and we've got teacher work days and they're going to have to go to all these meetings and learn all about all this stuff before the kids get here in a few days. And while the teacher's going through, okay, this child needs a potty chair, the child needs certain feeding equipment, the child, and I have to get all this stuff before the child gets here on Monday. And there's just an awful lot for new teachers to be aware of, plus read the IEPs of all 7, 8, 9, up to 12 kids in a classroom of self-contained kids. There's and when you talk about progress reports, there's so many deadlines to meet, that you've got to get as much done. You got to work with your kids, plus you got to meet all the deadlines to get the progress reports in, and then some teachers are faced with very special testing that takes not just one teacher, but a second teacher to proctor, which pulls her away from another teacher from the classroom. Because of the volume of work for especially EC teachers, you can only read your part of the IEP. I mean, there's some IEPs can be 16 pages, but some can be 60 pages. And that's all you can do to be the expert in your area, or read other areas that are close to yours. Teachers need time to read, to reflect, to think, to plan, to make phone calls, to get the equipment that the kids need. We need teacher mentors, especially for the new teachers. They're overwhelmed. They want to do a great job. They want to. They've been trained to, and they're just significantly overwhelmed. I say all, I don't mean all, I mean some who really want to do a good job. There's some teachers I work with who have 6 preparations a day. They've got kindergarten, 1st, 2nd, 3rd, 4th, 5th grade, and with special needs. The administrative staff, the principals, the APs need training in EC policies and procedures and direct contact with the kids, not just walk by the class and say, that's our EC class. They need to be physically working with the kids and know the students. And I think with relationships among people, that will probably keep us out of lawsuits, because I was just in that classroom, and there may be administrators making decisions about kids they've only seen on paper and don't even know the kid, but are making important placement decisions. So, Caroline, you're doing a great job. And you're doing the best you can. But teachers need a lot of support to do really, really, really well by the kids and the administrators and all the people involved.
And just thinking, what I had to do at home for data collection for my daughter. If you're a teacher, you've got 7 kids or 8 kids, however many kids you have in your class, that you have your data collection on, and you're trying to teach at the same time. Even if you have 1 or 2 TAs, I can't see how it's done. I had a hard enough time taking care of just one child and my house and taking data for the ABA therapist and everything else from a parent standpoint. So when we're asking for more data, which I think is greatly needed, we need to make sure we support the ability to collect that data so that it's accurate and usable.
Caroline, there was one more part. I'm sorry, I left out. Was that the teachers who work with kids who need help with personal care, changing diapers, spoon feeding, respiratory therapy, all that kind of stuff. They need to be able to teach, but they're also having to change diapers and do other things. And they're teaching while they're changing diapers, but they need EC assistance to help with all the personal care so they can really do the teaching.
Yep.
You're not going to get any argument from me.
Okay. You've always been very supportive.
Yeah. Well, I think it lends itself to the conversation that's come up publicly recently, and that is the funding for special ed students. And Bill would go on his little soapbox and tell you it was 1997, 1998 that we had the last
increase,
real significant increase in federal funding for students with special needs. And that, I always think it's important to consider that those students with special needs aren't special needs students from 8 to 3. Those are regular ed students as well. And many of our local districts receive their special ed funds to take care of their special ed students 8 to 3. Well, overwhelming majority of our students are in the regular ed class a majority of their day, or 80% or more of their day. So I think that's an interesting mix that people don't always think of when you think of finances. But we're all stretched for every penny we can get, and so all those things are ideal. And then when you have to make decisions about money, and it stays the same since 1997, it's a little challenging.
Yes, it is. Were there any other questions or comments? Yes, sir.
I just wanted to add, I really enjoyed all of the discussion and the comments that were presented this morning in regards to the Andrew case. As a former EC teacher, I certainly understand when you're talking about administrators who don't actually understand EC and everything that's required with that. And that was one of the things that actually drove me to actually enter the field into administration, having worked with several administrators where that was sort of put on the back burner. And we're very fortunate now that where I work, there's another assistant principal that works with me who is also a former EC teacher. And so we are able to work with our staff and with our EC teachers and our regular ed teachers to better understand the process and to work with them on how to better conduct IEPs and to not use, as we call, educator ease, to make sure that we're explaining things in clear language, just what all of these things that go into education and the decisions that we use for our IEPs. It's akin to like going to the doctor and the doctor's using their language and we're like, wait a minute, slow down. Don't quite understand what you're talking about. And so we have to realize that with parents too, that we need to do that as well, so that they completely understand. But there are a lot of challenges, as you all have alluded to and talked about specifically, that we face in trying to make sure that we meet the needs of all of our students. Because I know, unfortunately, a lot of times this becomes a numbers game, and administrators look at the greater numbers of regular ed students. And so we forget our students with special needs. And so the challenge now is to make sure that everyone is receiving the very best education possible. And so we are using the MTSS process with our EC students. We are looking at different types of data sources and triangulating that data to be able to come up with the best decisions and the best goals and objectives on our IEPs. We are progress monitoring. And so I think you made the point where you were talking about when you get inconsistencies in data, what do we do? And I would add to that, even if you go to independent sources and you go out and try to find that you're just adding another layer of different information on top of what you already have. So it becomes one of those situations where you actually have to look at all of the data sources and make the very best decision that you can based on that, because all assessments have some error. So we have to keep that in mind. But those are just some of the observations that I wanted to make and comments I wanted to make in addition to what was shared today.
Okay, thank you. All right, anyone else? I'm a little past the time budgeted for injury, so I think that it's appropriate now for us to take a little bit of a break.
Let's try to come back by 10:50, about 8 minutes. Should be enough time for people to use the restroom. But not be too far behind for the next section.
I'm so glad you came. I thought you tried about it. How long have you got on the board?
What's that?
How long have you been on the board?
It'll be saved for the next contract renewal period.
It'll be saved for the what?
Next contract renewal period. Basically, we missed the boat.
Because, okay, so I asked, what's her name? The lady, she's sitting at the end of the table. In that meeting, she works.
No.
Yeah, I think
I was way into deep thought. No, thank you.
You see that she's like the liaison between transportation and.
Anybody have your place for the next time?
That's what I didn't see anyone on there.
They've already got somebody really short hair, already got somebody to do it.
Because she said that, no, we still have another year on those contracts.
Shut up.
No, we were.
See, I don't see a replacement. Actually, this is my second term. I've done 2 terms, so. But I mean, for the court, what it means.
And how long are those contracts for?
Cooper's office every 2 months. I used to know it. I was gonna try to say
I
something.
asked her about that. I recommended somebody take it over for 5 years, and she said it never right.
But the process was like Tish, and they have to send a letter.
Okay.
I mean,
Yeah,
talk to
basically,
Tish, they're in the process.
Okay. Yeah, I was gonna try and picture and see what the process is. So who's taking it? Is your person?
But they had announced to the chair.
Sharita?
They're negotiating, it's not signed yet.
Where is she from? You know anything about her?
I did read when she was ready.
It's the potential to be here huge. 3 years, 8 years, leaving a chair and no longer. with nobody coming to pick them up. And you have kids
So
getting
you,
off the buses with seizures.
But, and that's, if you hear that, like what County talk, it's a lot of that, it's stuff that it doesn't have to be written in the contract, it's like the actual procedure.
Right.
Between how the drivers interact with students and the training that goes through them, so it wouldn't be written into a contract anyways, but, and again, the big gap is that we don't have a direct relationship with transportation.
Right.
And the gal that was there, they don't have anything to do with it. Like special ed service, I'm sure it's listed in the IEPs or the services.
Yeah.
Anything that happens after that.
Yeah, because now I did go back and I had the pediatrician write in for his IEP that he was not to be on an air-conditioned bus, and he was not to be on the bus for longer than 45 minutes. So.
Do they honor that?
Oh, they will.
I've had it where they don't, even if the.
Well, if it's part of the IEP.
No, I mean, even with the medical, I've had families that have provided like medical doctors information.
You tell who's they? Like, does the transportation company or does the district?
Yeah.
The company?
Yeah, no, the Wake County
The district?
Transportation.
They will.
And they tell parents, no one policy that your child can be on the bus stop or not.
If it is in that IEP, that is legal.
Well, that's what I'm saying, they won't even do that, even with your doctors.
Some physical.
I'll look into that.
Just keep it, yeah.
Yeah, because I've not had a problem with anybody saying that, but I could definitely see that happening because, we were also told that if John spent more than an hour outside of his class, then he would lose his physical services. So.
You told me that like that.
Yeah, so I can definitely see that happening. So I guess probably the best thing for us to do is just to find a way to get the word out to parents that, this is an option if you are concerned about if your child has medical concerns that could cause, I can't find the word, bad stuff. I can't find the big word.
No, I know.
But the MAPS program has like John, he deals, his occipital and cerebellum, they're all fine. So autonomic stuff is pretty fine. But he can't move, he can't twist when he is in his chair. So he's not getting circulation, so that's his issue. Then you've got kids like Rose. Yeah, like she has to meet him at the bus with an umbrella because if rain hits him, that's enough to startle him into a seizure. So, I mean,
good progress.
What is your daughter doing?
She got married and she's working in California.
What?
Microphone's wrong. We hear what you're saying.
Oh, they were in front. Put it in the record. So
Cool last time, now I'm warm this time.
I know, I'm sorry. It's so warm.
I was dressed to be cold from last time, so I was like,
And all this good.
So if I contact like the different organizations, they none of that I cannot get information about or is send information.
And then just like, I'll jump it, just to try and get people. But then, yeah, so like, these are big, like, our kids. So much.
And I spoke out.
Autism Society, yeah, again, all the,
Okay.
So you would hope would have cross-representation, but Jennifer shared the results of the survey. Yeah. It's response, fantastic. And they'll create a subcommittee that'll work on transportation and.
Has it ever been looked at? Has that ever come up?
Yeah, so this is 7 years, and they did have a subcommittee times that were changes, and then, like, everything was kind of plugging along, so you know what I mean, it's like, okay, everything's good, we should put this in the paper, and now, things have bubbled up again, so it's at that point. Stability.
Because then I was wondering if, like, because I saw that the policies and procedures on this interesting yesterday that that subcommittee
One of the
that
DSS
change,
folks who's in charge of
like simple changes for policies.
agencies that I just had to train
Each bus route has a folder. When you pick up the keys for your bus, you pick up your folder. And it's your responsibility as the driver. If you're sub regular driver or whatever to go through that.
What you were saying.
So I could and know the transportation expenses that the kids who are on doing them. And I know that their routes change, but take that paper out, put it in a folder.
Probably do some more and just.
It is. Well, and I asked her bus driver about it, and she said, "Oh yeah, we're required to do that, but the same company is the one that does it." So clearly, they're not checking on everybody. I have a question for you.
Yes.
Okay, so I have a very, very dear friend, and her high schooler was in the wrong place at the wrong time, and because he is black, ended up with a felony.
Okay.
Even when he was not involved in the incident
Right, just
that happened.
affiliated
They
there.
searched his home, did not find anything. He was still charged with a felony.
If we have anyone
And
else,
so
we might
his
have to
high
bring in more
school
chairs.
said that not only was he going to be expelled, he was to be
You might be
expelled.
standing room at the table.
So
That's a good
they
problem to
have
have.
lost their home because of legal fees
Right.
and everything. They are living in a shelter. It's the mom and 2 boys. And they have been able to get him into, I can't remember which alternative school it was. I can't remember. Anyway.
What grade is he?
He's either a junior or a senior.
Picture speaking
Yeah,
go with
he
what
is
you have
doing
daily in the classroom
A's
more
and
than what a
B's.
standardized test
He
says.
wants to learn.
Yeah.
He was out of school.
Oh,
for most
okay,
times
let me get that list
because
for
he
you.
wants to learn.
That's all right.
But,
So he is in
tracking
school.
communication,
doing
if you're trying to
fabulous.
track and
Is there
have
a way to
functional
expunge
communication skills
that
versus
from
Rebecca
from his
Richmond.
record?
you know, it's,
How old
you
was
have
he?
to watch like a hawk and this half
and
of
let
it.
me
Was he,
see.
so he was charged as an adult?
Kids all at once.
I believe so, because I'm pretty sure he's at least 17.
Was he 17 when he committed, when he was, when
He could have been
the
16.
committing act?
He's
That
at
would be,
least 16.
unfortunately, the way that it is right now.
Season ticket holder for the Panthers, so I'm fighting it quite a bit.
I want to say there's a way, you know, down the road that he may be able to get that as far as, I don't know, you know, that's one of the reasons
You know the
raise the age threshold and affect.
Back to, I live in Kerners.
I'll be honest with you, that's one of the reasons why
So
I
we
wouldn't
just,
kill
There's gonna be more protection for kids.
The incident was, this is what got under my skin the biggest.
I'm sure
was the
there are a lot
Because
of
so many middle
There were 4
schools, they only
boys,
offer
2
either
white,
self-contained
2
or
white kids who
full
actually
on
committed
co-teach
the armed
inclusion type
robbery.
setting. They
Were
don't
not
really
charged.
offer
The
somewhere
2
more
kids who were
resource in
black
between.
and were
Like
decided not even know the home that was got
I
charged.
just said that'd be a good thing for him.
So, and that it happened on a weekend, nowhere near the school. But it affected him at school. And I'm like,
Yeah, Rachel, she just got there.
Wake County, just in Wake County alone, with records.
Okay, microphone's running, by the way.
Yeah.
So, and this kid has
Becky, stop listening.
actions in school. He has never been suspended.
I know a couple years ago, I worked for
He's never been anything but a model
and
student. And there was so much,
I forget what
because when she came to
condition
the
he
6th
had
time,
off the top
they
of my
said,
head, but,
what
I mean, we
documentation
finally were able
do
to
they
get the school
have
to
that he
fund
had prior
a full
behavioral
educational
issues?
evaluation and implement
that
what
cannot
results
be
from
legal.
that, this
So they
suggestions,
spent months
right?
back
Have they ever gone, anybody illegal?
After that,
She
all
has
the
been
schools
to, I
on
think she's
board
been
that
to
knew
legal
what to
aid,
do
she's
with
been
the
to the,
student,
the
started being
prison
successful.
pipeline.
I haven't crazy high school now,
They
I think
helped
she
her
was
a
nice
little
about
bit.
that, but
Our church tried to
it's
help
all
her, but
been-
she's completely beat right now.
But it takes time to get to that. And you look at injury, I'm like, 8 years
And
to finally
she's
get
a single
somewhere.
mom,
I mean, by that
so she can't.
his school career is almost over.
Can't save enough
It's
Right.
to
ridiculous.
get back on her feet.
And I'm not sure, I can't remember off the top of my head which state that is, and if they have, since we have a two-tier system before you even get to
And he is, he
go beyond
wants,
federal.
he's not a,
With, different
up till Salisbury,
law
so
judges
it's all
and
just after the ball game, trying to get back home.
system that has happened to him and is keeping him from meeting his goals.
It's take even longer.
And it's gonna follow him on
I
his
think my
record.
great-grandchildren.
I would say, you know, that's
I'm in
the recommendation I would
Johnston.
have, for her to meet with legal aid.
Just down the road.
Always
Low or no
some kind of
cost.
instruction.
And, I may be able to, is your email on here?
They're gonna get high school.
Right here.
Yeah, that's me.
I can send you things. It was just contact them from legal aid about something else. I might be able to put you in contact with someone over there that might be able to provide a whole lot more guidance than what I can provide. This is, now you're getting yeah, the legal ramifications of things. But, you know, they do more than just, they may be able to help with like the housing situation. Because they provide a big scope of things.
Always tell.
Yeah, which I just clearly just found out about probably Tuesday. But,
Been an accident, cause right now it's our place.
or at least direct you somewhere, you know, with sitting there in front of it.
If you ever get a chance to go over to
It might be the best place to start.
over off Glenwood Avenue, it's called the Homeschool Gathering Place. It's Oak Peddler or something like that. Yeah, it's like a little hole-in-the-wall place, but they have tons and tons of curriculum materials and stuff like that used in it. So, I mean, even if it's just, you know, 1 or 2 areas you want to
just makes up the difference.
They're
Those
great.
hot dogs that have been shipping there these days.
Definitely.
Sure enough.
And I'm pretty sure it's because there wasn't anything to tell. And is your email on here?
Yeah.
Just in case, and I won't
Homeschool
bombard
Gathering
you with
Place is a great
anything, but,
resource, and there's so many different
just so I can
co-ops and
kinda help
stuff,
her
so
step
that you're not
Yeah,
really doing it
absolutely.
alone. You don't
Is
want
he
to.
at a charter school right now? Did he go to the one
I'm not
over
sure
in
on his
Raleigh?
science, but this
I
person,
think they were looking
is
at
a
that.
nurse, and she's teaching biology.
Works, right?
There's no coffee, there must be
She's teaching biology to all
That's
That's
That's a big fear of mine. Terrible math.
Yeah.
Oh,
There's
part of
a,
Wake County Schools?
person here,
Oh, Longview?
You ever see my
what was it
girls?
called?
He might be at Longview.
Okay.
Because we were looking at
That
the
math
charter.
guy, what his name is, what he does is he does, I think it says, I think it's
So Wake County Schools, at least, once they enroll within the
They
school,
He has
they,
his teacher.
After all of these courses.
2-day
She
thing.
has had all of them except
but he offers your higher level math courses here in Lake County.
yeah,
That one math
I
guy.
think, you know, legally it would be people to talk to on. And he's been there the whole year.
He has been there, yes, I believe he's been there this whole school year.
Okay, has he had any issues at school?
Not that I know of.
Okay, that'd be the other thing, because
All
part of
right,
it is
if we can,
a transition plan back to.
wrap up our conversations here in the next 60 seconds and turn our attention back to the
So,
meeting.
But he might be finishing.
Otherwise, we'll start banging my hand on the desk like a gavel.
yeah,
Right.
right.
Because they can only be there for 30 days. I think she's only gone.
Okay, just for the benefit of the group at large, I just want to let you know who has joined us virtually and joined us at some point during the presentation. That's Carla McNeil and Rebecca Richmond and Paulette Wall I mentioned earlier, and she's still with us at this point. So for those of you listening online, we're going to go ahead and get started with the second part of the presentation this morning. And I'm going to apologize to the new folks. This isn't usually the Carol Ann show.
We're loving it.
Thank you. Just my number got called this time for sharing information, so thank you for indulging me this morning. And I hope that it is meeting the needs that you guys requested of me today. Just sorry you're going to have to hear me drone on for a little bit more. Hope it hadn't been too painful, but we have a little bit more to go through this morning. Again, just as I mentioned earlier, if you have any questions, just stop me along the way, because I'm happy to give you any kind of clarifying information that you might need. So there's not a handout for this part, no. So I'm going to walk you through some technical changes that happened in the policies over the past year. We alluded to them before in previous meetings, and we've talked a little bit about them along the way as that became relevant to the conversation. But this is really a more cohesive look at the year in review and what changes occurred. So to create a little background or setting for you, we have changes to our policies in a variety of ways, or there are a variety of catalysts, if you will, that causes changes to our policies. And the policies I'm referencing is the policies governing services for children with disabilities. That is our state policy that we hold our LEAs accountable to, and we're accountable to ensure that services are provided to children with disabilities. So one of the catalysts for change is anything that changes the federal regulations at the federal level. And the big event that created some changes for us was related to the Every Student Succeeds Act. So that's one catalyst that causes changes is the federal. I'm going to walk you through the new IDEA website because the IDEA website was updated this past year. Might be just a little over a year. Some of you may have already been familiar with that, but I just kind of want to walk you through some of the things that we use as resources to keep up to date so that you can do the same. Then the Federal Register is the regulatory language that implements the IDEA. So IDEA is essentially the marching orders for what we're supposed to do for children with disabilities, and the regulations tell us how to do it. And so when those regulations are adjusted, we have to assimilate to what those changes are. And then, of course, our North Carolina policies governing the services for children with disabilities. I'll kind of give you a little bit of information about where to find that. Also, too, staff will email this presentation to you, so you're welcome to have this presentation for reference for the links in here. So this is the link to the IDEA website that has been updated, and this is the landing page. So what you'll find here, a lot of the things that we find particularly helpful in our division is looking at the Law and Policy tab. And this Law and Policy tab can be searchable by subject matter. So, for example, if you are interested in any kind of regulatory language or any guiding document relative to, for example, adapted PE, you could search that, and if there's anything in regulatory language that specifically addresses that item, or any kind of subsequent guidance document that the Department of Education or the Office of Special Programs has issued, you can find it searching it that way. So it has a whole lot of resources here. It has information for parents as well. I personally like the updated website. If you've searched the IDEA website before, you might have remembered that this landing page had the apples and the stack of books to the left, and the stack of books to the left were the different places that you could navigate. So they've linked it all now into this one hub, so you can find some of that additional information that was housed on that website at this new link, if it is still considered current and relevant. As you may or may not know, President Trump issued a presidential order that required all federal agencies to review their guidance documents and what they had provided to the field. And as part of Paperwork Reduction Act and other acts in that executive order, if there was guidance documents that were out on the website that were no longer appropriate, and that's for any kind of government agency, not just us in education, then that agency had to engage in activities to determine if it was relevant and current, and either sunset that information or issue something more current and up to date. So just kind of as a random tidbit or extra piece of information, to date, the ones that have impacted students with disabilities has been some old guidance relative to service animals under ADA. They've just pulled back some of that guidance documents. It doesn't mean necessarily that something has changed as much as that document is no longer considered relevant and valid, that maybe there have been subsequent guidance documents that are better addressing the issue. And so in order not to confuse the public, those old things have been taken away if it's been superseded by something else. Okay? Probably more information than you bargained for, but you know, bonus is a bonus. Okay, so let's go to the Federal Register. And again, if you recall, this is the how-to of the IDEA. It tells us how to do our job and the regulations that we are to adhere to when delivering services for students with disabilities. And it's not a very fancy cover. You can find a link to it on our website. And this was the original cover that was issued in 2006. After the reauthorization in 2004, it took a period of time to get all the regulatory guidance together because as we do, the feds had to put it all out for public comment and respond to that comment before it issued its regulatory guidance. So even though the reauthorization was in 2004, the regulations came into play in 2006. And so this is the bigger document, and subsequent releases kind of look similar to this, and it has the date on it. And on our website, under the policy tab, if you'll go to, there's actually a link for the Federal Register, and we have posted there all of the different iterations or updates to this document. It hasn't been updated in its entirety, meaning a whole new book, but rather inserts, if you will, or additional documents that have been coming released and subsequently put into play. So one of the things that is helpful when you're looking at the analysis of comments and changes in the document is this is some of the responses to the public comments that the feds received when the regulations were being considered and implemented. And the reason why we like to look at them is that it actually gives us a little bit of more transparency in the thinking of the regulation, because the federal regs are about this thick, and about this much of it is actually the regulations, like the rules to the game. The rest of it is the comments, the analysis of comments and changes, and that's helpful to us when we see them give us a little bit more detail than just the regulation. So I thought that might be of interest to you if you choose to look at this as a resource. Because if you look at the first page, not many of us would get to the second page because it's not a very easy, light reading by any means. So I'm going to take you back through time just a little bit and the updates to the register that we had to incorporate into our policies. And in the bottom right-hand corner, you'll see a cover of the new policy book. And it's my plan to bring everyone a copy of that at our next meeting because we'll be doing some orientation activities for our new folks. So I'll provide an updated copy for everyone at that time. Okay? So in looking at the Federal Register in April of 2015, there was some regulatory guidance about how local education agencies had to maintain their effort, their fiscal effort, with making sure that students with disabilities were being served with the money allocated for them, and that once we allocate money, the school district cannot get into a place where they don't maintain its own effort to match those funds to work with students with disabilities. So this is a bunch of fun stuff about we might allocate you money, but you have to put money into local education agencies to maintain the effort for supporting students with disabilities. And so our question might come about why, if it was issued in 2015, did we not update the book? Well, couple of things. We implemented this standard right away because we had no choice because it went effective, but it's often not cost effective to reissue the book because literally last summer, if I had issued a new book, I would have had to do it weekly because they were sending us federal updates last year. We just drank through a hydrant of federal updates in the summer last year. So we go ahead and typically what our practice is go ahead and communicate these changes. Like these changes came through grant training that happens on an annual basis when local education agencies are developing their grant to submit for their federal funds, their federal and state funds from the state. And so they were made aware of these standards right after they happened. So it was just a little bit of a lag to get them scooped into the policy book. Then in December of 2016, There was another update looking at how states are addressing the issue of significant disproportionality and how states are addressing discipline, including suspensions and expulsions. We've always had standards for significant disproportionality, and we've always looked at how students are long-term suspended and so forth. But now we have additional areas that we have to consider when students are removed for disciplinary reasons. The reason why there is a yellow check mark by the booklet at the bottom is that right after this came out, just a couple of months later, there was another notification provided by the feds that some of the guidance relative to how these calculations are done were under further revision. So you might remember when Dr. Nancy Johnson came and spoke to us about significant disproportionality, and you guys offered some feedback about how those calculations were to occur. It wasn't long after that meeting that we got notification from the feds that they might be reconsidering the ranges and the parameters under which states could actually have a choice in calculating that. And so we really, two things. This is an area that we're concerned about, and states have a right to go ahead and move forward with that. So we're not walking away from looking at significant disproportionality because there's stuff already in place. And we are continuing to wrestle with that because we're not necessarily wanting to wait for the feds to tell us the next thing, because there is work that we can do with our stakeholders. You guys, for example, have provided us feedback. And so what we're hoping to accomplish is by the time the feds get it figured out, that we will have obtained enough feedback on this topic that we can go ahead and within whatever new parameters they provided, implement the feedback from the stakeholders so that there's not any untimely delay with going ahead and addressing this matter that we feel is very important. So that's why it's yellow. Those changes have not been adopted into our policy book at this point because there was another proposed rulemaking on this topic. So the current requirements are still there, and we're waiting for any new additional pieces that the feds are going to gift us with. Okay? All right, so again, this is just a little bit more on significant disproportionality. It includes some responsibilities about revising our policy practices and procedures. What do we do? How do we address those factors? How do we use our early intervening money through CEIS to intervene before these things occur? All of that has a basis already in policy. There's already regulations that we're following on this topic. Again, we are just waiting for the final on that before it becomes adopted into our policies. Okay, then in June of last year, we finally got the regulatory requirements as a result of the Every Student Succeeds Act. And this is where we had a lot of interest in what it would mean for children with disabilities under IDEA. Because Every Student Succeeds Act was the reauthorization of the Elementary Secondary Act, which then informs, of course, what we do for children with disabilities. So if you guys remember, or maybe, it may not have popped on your radar, but we were all waiting to see if the IDEA was going to be reauthorized too because of the ESSA. And currently, that does not seem to be the direction or the climate, as I'm aware of it, of opening up the IDEA right now for consideration. So I've not heard anything about any beginning movement toward reauthorization activities there. So we did have to attend to what ESSA did for us, and from my perspective, I didn't consider the changes upsetting or unfavorable to students with disabilities or taking away some fundamental rights that we need to have for students with disabilities and their families. I know that's pretty much of a general statement, but as we kind of get into this a little bit further, it's detail-oriented, but really it wasn't, in my view, substantive change to the business of what we do on a daily basis. Okay? So, what it did is it handled some definitions. It made some revisions to definitions. The definitions that were changed or revised a little bit was charter school, limited English proficient, and some language in the regular high school diploma. And I'm going to walk through that just really quickly in just a few slides. And then there were some definitions that were removed relative to core academic subjects, highly qualified special education teacher. Now, don't panic there. That's okay. And scientifically based research, okay? What happened here, let me go back. So charter school really just assimilated its definition to be concurrent with that of ESSA, and it really didn't change anything to describe what a charter school is. It was just a little bit more language to add on to that definition. It's still recognizable as the same definition and that is in practice there, so there wasn't really anything substantive there. Limited English proficient. Over the years, we've known this as ELL, LEP. Well, this is LEP and ELL reimagined again for English learner. So it just really, this English learner is now the more appropriately politically correct term when talking about students who have language differences. And then regular high school diploma, I do actually have a slide for that, and that just added some extra language. Again, it doesn't take it out of being recognizable from the operational use of that definition that's currently in place. Okay, and core academic subjects. This was where you had your reading, writing, arithmetic, you know, all of that was kind of spelled out. Well, core academic subjects can look different from state to state and what's considered core. So what you'll also find through ESSA is that it walked away from the notion of being really prescriptive in certain areas to give deference to states to be able to define these things as appropriate in their states. And core academics was an example of that, how the thought was that we don't need to define this for states, that states can define what core academic subjects are themselves. And highly qualified special education teacher, I am going to spend a little bit of time on that because there's a change in what, of course, is in the regulation, but it's not a change to what we do in practice in North Carolina. So I want to spend a little bit of time being explicit on that. And then scientifically based research. ESSA has favored the definition or the use of the term evidence-based research. And essentially what has happened is that they've just vacated defining scientifically based research. There's a lot of ways to describe the research that is used as the basis for the education that we provide students. There's evidence-based, there's scientifically research-based, there's a lot of different descriptors out there talking about and trying to describe the research. Is it peer-reviewed? Has it been implemented over time with a set number of students? All of that is kind of common in our field to define the level of research that has been done on the instructional practices that we provide. This is an example of the feds walking away from defining that because in addition to that, it raises the question, if this is scientifically based research and you have a textbook, you know, how does it match up with the definition of scientifically based research? And, you know, South Carolina, do you have a scientifically based research threshold that this textbook matched, but North Carolina does not? So that's a real tortured explanation to say that they don't want to define that too tightly. And the terminology that they're choosing to use is evidence-based research, but as sometimes when we get gifts from the feds, it's not really a gift because they didn't define evidence-based either. So how would you like for us to proceed. So, you know, it's just one of those things, the gift that really didn't give anything. So you will still see scientifically based research in our policies because, again, just because the feds didn't choose to define it does not mean that the term cannot be used. And states are defining that as it is appropriate relative to their instructional practices.
Just have a question
Sure.
really quick about the kind of like what your thought process is on like the having highly qualified special education teacher removed from that, because there's special education like you'd want a highly qualified special education.
It really didn't go
Semantics.
away.
It's
just words.
Anything.
And I'm going to get to that because that is a really good question, and I have about 4 slides that I want to spend on that. No, keep your thoughts in mind because if I don't get it, I want you to come back to me, okay? Because
your children are still being taught by highly qualified people.
It just sounds like, ooh, why would they?
Semantics.
Yeah, I don't want loopholes.
It's semantics.
Right. So I'm just going to kind of go ahead and address that in a basic way. Even though the federal regulations had highly qualified as a special ed teacher, there wasn't really a property right associated with the words highly qualified. It was just additional descriptors. Now, you had to have, under personnel qualifications, a special ed teacher, which of course is licensed by the state. You've had to have a program of study. You actually have to have the ability to work with students with disabilities. So the highly qualified was intended originally to put some extra impetus behind certification of students, of teachers to teach students with disabilities. Those qualifications under highly qualified, it was under its own section in the regulations, but they've moved those requirements under the personnel qualifications. So they didn't really go away, they just moved over into another section of the regulations, and some of the terminology like highly qualified as the adjectives kind of moved away. And I'll get there in a minute to show you what is or isn't there, because it's like a little shell game, and it really doesn't change what we do in practice in this state. Okay. All right. The other thing that was done is to clarify the guidelines for children who are taking the alternate assessments to measure their academic progress. In other words, what this did is put a little bit more language around students that are taking the alternate assessment to ensure that it's really just used for those children who have the most significant cognitive disabilities and that are participating on alternate achievement standards, which in North Carolina would be the extensions. And it's really making sure that states are really carefully looking at how they make decisions for this assessment, because it impacts children and their 4-year plans, their rigor of their program. And it's a very serious decision that when you are contemplating this as an appropriate method to evaluate students and provide instruction for students, do parents understand that that is not going to lead to a regular high school diploma? And what does that mean? And when is the best time to make those decisions? And how do we appropriately maintain the rigor of the educational program that the child is experiencing so that we are ensuring that they're getting every opportunity possible to have a program that leads to a diploma? Okay? All right, and then looking at requiring the state to provide technical assistance regarding comprehensive and targeted support improve activities based on consistent underperformance of children with disabilities and desegregated subgroups. In other words, this is kind of related to the significant disproportionality. What are we doing? What are we doing for kids who require additional supports because they're underperforming as a group? Again, this is intended to raise the rigor of what we do for students with disabilities and the instruction that we offer. The other update that we have is relative to ROSA's law, and that was an update in July 11th of 2017. And essentially, it just ensured that in every federal document even those related to students with disabilities, that the term mental retardation was replaced with intellectual disability or intellectual disabilities. I don't know about you guys, but I kind of took a deep breath. I thought that had been handled a long time ago. But, you know, evidently there was some terminology in federal documents that needed to be updated. And, you know, we certainly went through our process to make sure our language was updated as well to reflect the terminology correctly. So then we get into policies, our policies governing children with disabilities. And I still haven't forgotten about the highly qualified because I'm going to show you in this section. So you keep me honest, Katie, okay? All right, so what does that mean for our policies? You know, that's all the federal stuff. So how did that look like in North Carolina policies? Well, one thing about North Carolina policies is it is essentially verbatim what the federal regulations say. The major differences in North Carolina policy is that we have a class size requirement. That is not a federal requirement, that is a state requirement. We also in the state look at 90 days for from the referral to placement if the child is an eligible child, and the feds look at 60 days from the date of consent to placement. So North Carolina elected to go a little bit beyond that and scoop in from when the child was referred all the way through placement so that we can keep things moving at a reasonable pace to identify students. And then in transition, we have some required transition activities that we ask LEAs to engage their IEP teams in at age 14, and federally it's required at age 16. And so those are just some examples of where differences are, but essentially we have adopted pretty much letter for letter the federal regulations. I mean, we have to accept them in. I guess what I'm trying to say is that there's very little that we have either added to or expanded upon, and I just kind of wanted to pull that to your attention. So this will be helpful if you ever wanted to compare the old and the new. This is just where I walked through with LEAs previously about where you could find the old information on what pages and what pages there are in the new book. And again, that's just to show where we adopted in the new language and where it appeared from the federal regulations. Here is the information from ESSA. Again, as I mentioned earlier, it only amended the authority citation to reference ESSA. The definition had a reference to the High School and Secondary Act, and so that was an update there. We talked about English learner. I've highlighted here on the slides the different places where those changes had to occur. Then in looking at the regular high school diploma, the section that it reflected where the federal changes were is under 1501, the limitation exception for FAPE. And here is where I highlighted that for you. If you look in Roman numeral 2, or II rather, that paragraph is the one that had to be amended, so that's why you see the strike through. Just only because it was easier to see in the bottom paragraph what language was new. So it took that paragraph and added the underlined part. So if you see that regular high school term means the standard high school diploma, it added some extra language here saying awarded to the preponderance of students in that state. In other words, the high school diploma that most children receive in this state. And then it just had some extra language about what a regular high school does not include. And again, it was just some extra descriptive language about equivalence, diplomas, completion, certificate of attendance, those things that do not constitute a definition of a regular high school diploma. So that's the example of the minimal changes, just some extra descriptors that were added in as a result of ESSA. So again, these are items that were removed, and these are the locations under which the information was and where it disappeared from. And now we're back to highly qualified special education teacher. So the highly qualified special education teacher, these are the parts that were under that section in the regulations just before they were changed. So this is the old information, so I wanted to go through that first. So this part of the regulation talked about teachers that are teaching the core academic subjects. What kind of credentials did you have to have if you were a special ed teacher? What kind of requirements did you have to have if you were teaching alternate standards? And if you are following along here with me, this is where our state looks at general curriculum for EC teachers and adapted curriculum for EC teachers. And this was the regulatory language that we based those two types of licensure on, okay? Then it had the requirements for special ed teachers teaching multiple subjects. For example, the teacher of record, did they have the appropriate content area specialty in addition to their special ed licensure? Also, there was a matrix called the House Standard. I can't remember what all those wonderful letters mean, but it was a matrix in which teachers could demonstrate how through their professional preparation and any kind of other college work, work experience, teaching assignments, that they could have that highly qualified status added onto their license. And I'll just give you a personal example of that. I used the House assessment when I was a special ed teacher at the middle school level. And this was in another state, so just kind of bear with me. I had a license in K-12 special ed, but I taught a separate setting for students with disabilities at the middle school. So therefore, I was a teacher of record not only for their special ed services, but also for their core content areas. And because I had been a biology major and had done other things in college, I was able to demonstrate my college preparation work to be highly qualified in the core content areas for math, science, social studies, reading, all of those areas. So that's what teachers had to do to demonstrate their highly qualified status. They had to demonstrate that they had experience to be able to add on those other areas. Okay, so essentially these were all the areas that either were adjusted, removed, or moved over to personnel qualifications. And so those kind of went away. So again, I was talking to EC directors as they were about to fall out. I was like, okay, this does not mean the world as we know it has changed. Okay, we still have requirements for teachers. No creative use of staff is permitted. Because we have those special education adapted curriculum and general curriculum licensure tracks for a reason, because we want people who are teaching our children to be able to do so and be effective at what they're doing and be able to effectively design instruction and make recommendations about the least restrictive environment for our students. So guess what? It didn't go away for North Carolina at all. Okay, because we do have State Board of Education policy that names out these licenses. Now, what we do want to do is some of that language that went away under the highly qualified about children who are on essentially the adapted curriculum standards or those extensions. We want to take some of that language and recommend to the state board that we add those right on over into the personnel requirements, because that is the expectation in the state, and that is what we require when we go and visit, but we also understand that we need to have the policy guidance to support that. Even though it's in state board policy and other places, we want to make sure that it's a little bit more specific. So it has not changed. Are you with me, Katie?
I'm with you.
Good. Okay. Anybody else have any questions? Any of our higher ed folks or anybody else want to ask any questions around this? So you have to have a license to teach special ed. It's not the wild, wild west. Okay?
Carolyn, I think the one thing to note about that is that we are held accountable by that on the human resources side, because if our teacher's license won't match the children that they teach, then we have an audit exception, which could be payback money to the state. So we are highly monitored with what license we.
Yeah, thank you, Christy. Yeah, so those guidelines haven't changed because we have removed the two words highly qualified. The licensure requirement still lives and breathes. Okay? So those qualifications moved under personnel qualifications. You still have to have a license to teach. And this is just the citations where you can find that information about how it moved. I had a little Q&A breather here. Anybody have anything they want to ask about the federal changes before I slide on over to some other things? Yes, ma'am.
I actually had a question about the teacher qualifications. So
Sure.
there's still situations where there are EC teachers that aren't qualified or have license, that they're going to school, lateral entry or whatever it's called. So could you talk a little bit about that? Because I do know of parents that, you know, coaches have been hired to teach in the classrooms that have absolutely no academic experience whatsoever. And again, recognizing the climate that we're in, there's a tremendous shortage of teachers. So I know they're trying to get people in. But how does that process work? They're also, you know, hiring a TA who might be going for her test, and then, you know, your child could have this TA all year, and I know of a specific example where then she failed the test and decided, well, I'm just going to stay a TA. So how does that fit in the whole process?
So I am not the licensure expert, but I do monitor licensure for the purposes of programs for students with disabilities. And so I'll give you a variety of information, and hopefully that'll be enough to kind of get to where you're going here. For us, it is an exception, meaning like Christy's example is an exception to the audit. If we go in and the teacher does not have a license for exceptional children, that's not appropriate. So what is difficult about answering your question is LEAs make assignments of teachers based on the information and their review of the teacher's credentials. So there is the lateral entry license, which means you have a license of some type to get a lateral entry license. And then there are teachers like the coach who might be doing an add-on to add on special education. And so to me, that I laughingly told somebody yesterday that we have some places that lateral entry is a state of mind because it's a license. You can't just say I'm lateral entry. It is a license that has been issued. And then there's the add-on. Well, the add-on is great, but it's not going to buy you a special ed teacher unless it's in hand. So it can't be a state of mind about licensure when we go in and look for the credentials of special ed teachers. Our expectation is that it's a licensed EC teacher. Did I get somewhere close? Mm-hmm. Okay. Anybody from an LEA that want to add anything to that? Or
I would just say they still have to meet qualifications to even be given a lateral entry license, and the state still has to approve that lateral entry license, such as going into an adaptive classroom for the extensions to the standard course of study. The teacher has to pass the praxis prior to going into the classroom, and then there's a plan of study that our LEA has you. We have to have a plan of study in hand, knowing how you're going to get there, and that keeps us actually from having substitutes in a lot of our classrooms because of a shortage of teachers that we have. I have a lot of lateral entry teachers, and then I have some teachers who have been regular ed or in another field and can just take a praxis and add on an EC degree. We have recognized that there's a lot of support that we have to provide our lateral entry and our BTs, beginning teachers, but we know that and we address that up front through a teacher support program in our district. But so I will say that they are licensed.
Mm-hmm.
We don't, if they weren't licensed, then they have to be a substitute teacher, basically. I know our district, that's how it works.
Yeah.
For the children that they serve.
Yeah.
So I think there's some distinction between, adaptive curriculum and the standard curriculum in special education. And I could be a special ed teacher for 20 years and have a general curriculum license. And if I have a student comes to me who needs the adaptive curriculum, that doesn't mean that I'm still not a great teacher, but I have to go back to school and pass the praxis to get a full another license to teach that student. So that puts really small districts in quite a bind. But that doesn't make you an incapable teacher. That means you just have to do additional things to have a student who's on the adapted curriculum, but you are not qualified to teach that student if you have a general curriculum. So it's kind of specific at times.
I'll go back and reference one thing that I kind of skipped over on this particular slide. There was a licensure guidance tool that we issued for all of the LEAs in August of 2015, and it does a correlation with the general and adapted because, as we know, our workforce has come through schools and been licensed at different points in time, so their licensure might say different things, but are equally appropriate as long as it's based in exceptional children. So that's a little crosswalk. It also indicates a way that the teacher can, the LEA can look at the composition of that teacher's classroom and match it appropriately to the student's disabilities in that classroom, and then further on to the appropriate licensure. So there's a couple of things that come into play, the student's disability category again, and then the program of study that the child, that the students are working toward. So those are some tools that LEAs use to make sure that they're assigning their staff appropriately.
And I just had one question about licensure. I'm not sure if anybody can answer this. This was a loophole that we fell into in the World Languages Division. If a teacher is part-time, they are not required to have a license in order to teach. So that's happened to us a lot with the languages, that schools, instead of hiring a language teacher, they'll hire somebody part-time so that they don't have to get the license. Is there any possibility that we could have a special ed teacher who was part-time, like if you've just got kids who are pull-out? And would
So
that same loophole happen?
Yeah, I'm not familiar with that animal or that loophole.
Okay.
So that means that I don't think that that's kosher, but I don't know the particulars of that situation, the teacher's credentials, how that LEA has chosen to make that job assignment. So I'm a little bit at a disadvantage to speak to that more thoroughly, but you got to have a license to teach, whether it's general ed or special ed.
I just didn't want, like, I don't even know if there is such a thing as a special ed teacher being part-time, but if there is, that loophole does exist, and it might need to be something that we.
So the only thing that I would offer to that is if you had a teacher part-time, I would still be looking for the EC licensure for that person.
And Carolyn, we have part-time teachers who get in actually, and they are still required to have licensure anytime EC children, they're serving EC children. So they have, I've never heard of a loophole because it would come up as an audit exception from the human resources side and from
my office.
I was the loophole for the world languages because I was only part-time, so I was not required. I wanted my NC license, but they said, oh, you don't have to have one because you're part-time. So I just wanted to make sure, like, nobody knew that that was in there either. So if it really is in there, then I want to make sure that that's closed for our kids.
And there's also the semantics of part-time equaling substitute equaling different ways to split hairs on that. But I don't know world languages particular, so I would hesitate to offer any kind of feedback on how they chose to do that.
Department was different or whatever. I just know that that one existed and wanted to make sure that we don't.
It could be, but I'm going to stay in my lane on this one.
I don't know you.
So, are there any other questions before I move on to some other parts of this presentation? Anything else? Yes, ma'am.
Carolyn, one of the subjects you covered about the policy book, you mentioned class size requirements. And in my 8 years on this council, that's one of the questions I've gotten the most that I wanted to share with y'all. In this policy book, there are a couple of pages. I want to say it's page 139, page 140. There's a very important chart. It says class size requirement. It doesn't say class size suggestions. It says requirement. And it talks about the number of kids a teacher can have in the classroom and the supports that are needed as far as the teacher assistant. And that would be a really important document to make sure it's highlighted with teachers so they'll know for themselves as well as the supervisors of EC teachers.
Yeah, and I'll just add a little bit to Vicky's comments. Earlier when we started this part of the presentation, we talked about different catalysts of change and what creates change in policy. We just talked about the federal ones, and you actually gave me a perfect segue in terms of the legislature requires us to do activities as well. And so the class size policy was a directive of the legislature that we had to adopt into policy, as is the House Bill 149 for dyslexia. So again, I think to Vicky's point, or maybe not her point, but her urging you to consider that. If that is an area that you think is not working well or could stand some more clarity, that's a place where this council could advocate with the legislature about any kind of recommendations that you might have as far as what needs to be considered in that area, because I will also add that was legislatively required, but funding was not adjusted to accommodate those requirements. So that is another challenge with that. So anything else you want to add to that?
I think you do a great job. You always make things sound prettier than they really are.
Well, I picked up some skills along the way. All right. So House Bill 149 regarding dyslexia. So we had this bill from the General Assembly. And basically, it was to respond to concern from parent advocacy groups and other groups relative to the appropriate delivery of students who may have dyslexia. And we've actually kind of talked in this council over the years about different experiences families that you have worked with have had regarding ideas that we don't test for dyslexia, or we don't provide education for dyslexia. And certainly we've issued things to the field to say dyslexia is an okay word, you know. And so dyslexia is one of those types of learning disabilities that must be addressed, if appropriate, with specially designed instruction through special education, or other means in core, if that's more appropriate for the child to receive adjustments in their core education. So the General Assembly elected to assist in the effort of helping people understand dyslexia is not a bad word, or is not a word that we don't address, and it's not something that we don't attend to if that describes a student's unique needs. And so where it is organized into is essentially 4 parts. The first part directly impacts our policy in that we had to adopt a definition of dyslexia, and I'll show you that on another slide. The other 3 parts are different things that we have to engage in to support LEAs in the identification. So what do we as a state do to help LEAs have appropriate assessment tools and look at appropriate strategies for addressing this issue? How do we help LEAs appropriately identify those unique needs that may be related to dyslexia or dyscalculia? And then what resources are available to parents, educators, and other groups? And then part 4 is local boards of education had to review their own tools and screening instruments and make sure that they had those multiple sources of data that we talked about a little bit earlier to ensure that children were appropriately being identified, and if identified, were having their needs met appropriately. So we've lived with this for a little while now, and I think I can anticipate a question about what did we do about it. So we hosted a set of webinars, and I'll get there in a minute. I forgot I made a slide for it. So let me back up. So this is the definition of dyslexia that we adopted into our policy book, and it's on page 8 there. And then what we did to make tools available to both parents and teachers, or information available to parents about what we did to support teachers and LEAs. We hosted a series of webinars that we recorded, and we made those slides available to LEAs to re-deliver at the local level with the facilitator notes, the slides, the legislation for references. And so on this slide, you'll see that hyperlink there that can take you to these materials, so you're able to hear that same information that was delivered, and the technical assistant, any kind of resources or explanations that were offered as a result of the requirements laid out in that legislation. So before I go any further, any other questions about dyslexia? Okay. Getting close to lunch and you've had enough Caroline time, I can tell. All right, so then the next group is changes that we initiated at the EC division. We also believe that if we ask LEAs to continually examine what they're doing, that we should do it ourselves. And one of the things that we took a closer look at, and we have had in place for some time, is the LEA self-assessment. That was formally related to a plan that had already been in place called a Continuous Improvement Performance Plan that LEAs had to submit and outline their plans for improvement at the local level. As we began the work with LEA self-assessment, we acknowledged that we needed to update our terminology in the policy to reflect that. And the additional pieces that you'll see in blue essentially are, of course, making sure the terminology is consistent, but in Part C, we actually spell out the required components of that, which looks at the current status of the core elements. So policy, compliance, all of those pieces of those core elements, IEP implementation, engagement, all of those levels are there, that the LEA has to do an analysis of their implementation and look at their data, and that they have a plan to improve areas that they have identified as needing to be strengthened in their delivery of services for students with disabilities. So that was one change there. And so this is just all the different places. It's under class size as well, that we could look at class size through their continuous improvement performance plan. But again, the terminology just needed to be updated for the self-assessment. And then the next one was related to how we engage in the process for identifying students that may be suspected as having a visual impairment. And the reason we did this is that the Office of Special Ed Programs did release a memo in May of last year that essentially started out with, "It has come to our attention," and that's when we know we're in trouble. But it wasn't just to us, so it was nationally issued that from time to time we have to reevaluate our practices and how we are engaging in identification. And essentially what the observation was is that in the area of visual impairment, many states had elected to put in criteria that essentially defined how poorly sighted you were before you could be identified as a student with a visual impairment. Well, the reason why that causes a problem is if you look in the regulatory language about the definition of visual impairment, which is the very last bullet here, it says any impairment in vision, regardless of severity, must be included in the state's definition, provided that the impairment, even with correction, adversely affects the child's performance and requires special education and related services. So one of the first questions that we got is, oh my goodness, so does that mean every student who wears glasses now is eligible for special education? And our response to that would be, it depends. Okay, because a child who wears glasses, those glasses are the correction, but that's only one piece of the puzzle for eligibility. There is that three-pronged test for eligibility for any eligibility category. Is not only do you have a disability, but it's got to adversely affect your performance, and it adversely impacts your performance to such a degree that you have to have special education and or related services in order to make progress. So the eligibility requirements are still there, but states should not and must not put an acuity range or some kind of parameter on how poorly sighted an individual is before they engage in the process of considering eligibility if someone suspects that that child has a visual impairment that may be in need of special education. So what that looks like is that in North Carolina, we were one of those states that had put in some restrictions here that unnecessarily tightened the meaning of the definition of visually impairment. So we had to really walk away from that, and rightfully so, because we could have, unfortunately, overstated the federal definition to restrict it too far for identification. So in the first part, in our definition, we had added everything you see there by number 14 that is not crossed through mirrors the federal definition exactly. North Carolina added the last sentence that was crossed through that says a visual impairment is the result of a diagnosed ocular or cortical pathology. Well, that unnecessarily restricts, or it could. So what we're trying to accomplish here is that we don't make a number be the one thing that prohibits a child to be eligible. If all the other areas are met, then that child should be considered as a child with a disability if they're meeting those 3 prongs of eligibility. And what, unfortunately, that this could do is that this child could meet everything, but they may not have the acuity range you see in the below part of 20/70 or 2200, and someone could inadvertently say that they're not eligible because they didn't fall in this range of acuity. Now, people take a big gasp here and are like, oh my gosh, do we have this whole population of students in North Carolina that were not appropriately identified? It's not likely, because remember, the policy has always existed that your decision has to be based on a preponderance of data. So if there is a preponderance of data from multiple sources of data, then children should have been identified appropriately. But Carol Ann, what if they didn't get it right? So if anyone suspects that there is a child with a visual impairment that has an adverse effect to their educational program or needs special education, then they need to suspect a disability and refer the child for an evaluation. Okay. The other thing is that typically when students are suspected of a disability, maybe not typically, but you can suspect more than one disability at a time. So children with visual impairments or suspected visual impairments might be suspected of other things. But regardless if they are identified or not through special education, they still have to be provided an appropriate education through general education and still may have access services through a Section 504 plan if they need some level of accommodation or so forth. And this is a low incidence population in our state. The big story here is that we did a lot of training around this in terms of putting some information out there to make sure directors were aware. Teachers of the visually impaired have had some subsequent information from our content specialists, and just really calibrating about what it means to suspect a student of a visual impairment and how we should engage in that eligibility process for them. Questions for me? Okay. So the resources that we made available here are, we did a policy spotlight on this topic as well, where we did a virtual webinar, and here are the materials You see when it was delivered, the resources there, frequently asked Q&A. So all the support materials that accompanied that change and that messaging to folks, that's where you'll find it. And I can release you from hearing me drone on and on and on unless you have questions. But that concludes the changes to our policies over this past year.
Thank you.
I guess I earned my keep today. Be sure to tell Bill.
All right. Thank you very much, Carol Ann. So who else hungry? All right. Well, then let's go ahead and break for lunch.
We have just a little
sorry.
slight change. We actually have the lunch set up in here.
Okay.
In the school common area, since the state board folks were occupying that area.
Okay. Go that way. All right. And we'll come back about 12. Committee work starts at 12:15, so I say grab your plate and maybe go ahead and start committee work a little bit early. Okay? Sounds good? If you don't have a committee, please see me. I do have a list of who's on various committees, and I'll try to flip this out well, I'm going to do this right now. Oh, I only have enough. Never mind. All right. Well, I'll get this to the different committees. We have a Met Needs Committee, Policy and Procedures Committee, Reports and Data. So, for new folks, if you're interested in joining one, we'd love to have you.
Maybe the chairs could tell us like where they want to gather after.
So most of you guys are over there, so over there.
Come over here.
Can you also kind of define the scope of the policies and procedures?
According to this here, they comment publicly on rules or regulations proposed by the state educational agency regarding the education of students with disabilities, advise the SEA in developing and implementing policies relating to the coordination of services for students with disabilities. They've also in the past been involved in bylaws for this body, procedural things such as when we did public comment and come up with our procedures and policies around that kind of work. Does that make sense?
Yes, and I saw that there was a vacancy. Is that just for the chair?
Yeah, I believe so, because I think I have one person that's on it and one other, and she's on both of those two committees, so I don't know how that's working for Katie. So, all right. So is there any other questions?
Well, I don't know if I'm sure.
If you want to be a chair, I'd love to have you.
There you go.
Well, if I understood it better, or if I can understand it better, I will, because I got ideas.
I love ideas.
And
Let's
I'm
get
more than
busy.
willing to be that mom, so.
Yeah, wear that hat. All right. Well, it sounds like dinner or lunch is back there, so everyone feel free to help yourself.